We will start the event shortly. Before we start, I request participants kindly keep your devices on mute while the presentation is going on. Switch off your videos.
Vanchika, can you hear me? Vanchika, can you hear me?
Yes, sir, you are
Yes,
audible.
sir, we can hear you.
Is Principal Ma'am joined?
No. Our principal ma'am would be joining very shortly. Within 1 or 2 minutes, ma'am would be joining us.
We will start the session shortly. Before we start, I request participants kindly keep your devices on mute while the presentation is going on. Switch off your videos.
Please start.
With your due permission, Principal Ma'am, may we start the session?
Yeah, please start.
A very good afternoon to one and all present here. I, Ms. Nehal Jan, President of Research Advisory Committee, welcome everyone to the panel discussion on unlocking the potentials of intellectual property rights. It's my immense pleasure to welcome Principal of Aditi Mahavidyalaya, Professor Mamta Sharma, resource speakers Dr. Shikha Gupta, Mr. Ajay Singh Rajawat and Mr. Shailendra Singh, teacher in charge of Commerce Department and convener of Research Advisory Committee, Professor Bhavna Rajput, all the faculty members and the participants. Now, I would like to call teacher in charge of Commerce Department and convener of Research Advisory Committee, Professor Bhavna Rajput, to give the opening remarks of the panel discussion. Over to you, ma'am.
Thanks, Nehal. A very good afternoon to everyone. It is with great honor and pleasure I welcome our esteemed panelist, Mr. Ajay Singh Rajawat, Project Director under Ministry of Home Affairs, Mr. Shailendra Singh, Examiner of Patents and Design, International Search Authority, and International Preliminary Examining Authority under Ministry of Commerce and Industry. I also welcome moderator of the session, Dr. Shikha Gupta, Security Market Trainer of SEBI, Principal Ma'am, Professor Mamta Sharma, faculty members, research scholars, and my dear students, to this panel discussion on unlocking the potential of intellectual property rights and copyrights organized by Research Advisory Committee and Department of Commerce, Aditi Mahavidyalaya. Friends, as you all know, knowledge and ideas are the key resources in the global economy. To be a successful person, business, or an entrepreneur, one must think of out of box creative solution or method or the processes. Intellectual property rights provide certain exclusive rights to the inventor or creator of the property to protect his invention or creation for a certain period of time in order to enable them to reap commercial benefits from their creative efforts. With stiff competition, there is an increasing need to protect the rights of such innovator from duplication and unfair uses. Therefore, there is a rising demand for the protection of intellectual property around the world. Intellectual property rights are important drivers of the economic growth of the country. And so, for the inventors and entrepreneurs who are constantly competing with each other to stand out in the market, intellectual property rights are essentials to them. The topic of panel discussion is quite relevant for our country, as even though India has improved its IP score by 13%, but it still ranks 43 out of 55 countries as per International IP Index 2022. During this pandemic, there has been a big surge in the pirated content in India. The rate of music piracy in India is 68%, which remains significantly higher than the global average of 30%. And the worrying fact is that Indian demand for pirated content may be double or triple the global average in near future. Not only it affects the India's position on global IP ranking, but also endangers the work of domestic creator and many innovators. The lack of IP laws leads to instances of content theft and copyright infringement, a problem that has exaggerated with increasing internet and smartphone penetration. According to the research conducted by US India Business Council, Indian film industry has experienced around 11% loss in the employment due to piracy alone in the recent year. Not only the figures are concerning, but also deters us from achieving the global recognition and puts our domestic content creator at a significant risk and loss. So today's panel discussion is organized to create awareness about the IPR and to appreciate the significance of protection of IPR. And I'm sure that session will provide the valuable and engaging content to all of you. So with these words, I would like to thank everyone to join us for and participating in the panel discussion. Over to you, Snehal.
Thank you, ma'am, for your enlightening words. Let us now welcome a woman who is well known among all of us for her wisdom and knowledge. Our admirable principal, ma'am, Professor Mamta Sharma. She is a university rank holder, has been teaching chemistry for the last 3 decades after completing her PhD from University of Delhi. She has published widely in the journals of national and international repute. She is the recipient of the Research Associate Award from UGC, Icon of Higher Education Award 2019, and an Outstanding Educator of the Year Award for service towards person with disability. She has completed various research projects and organized numerous national and international conferences as a convener and resource person. Now I request the principal ma'am to kindly address the students. Over to you, ma'am.
Good afternoon to everyone. It's my immense pleasure to address you all. As we all know, today we have a discussion on the topic unlocking the potentials of intellectual property rights and copyright. And we have Dr. Shikha Gupta, resource person, CDSL, subsidiary of National Stock Exchange. Mr. Ajay Singh Rajwat, project director, Shastriya Raksha University, Ministry of Home Affairs. Mr. Shailendra Singh, examiner of patents and design, NIPAM office, Ministry of Commerce and Industry. Intellectual property rights are the rights given to the person over the creation of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Intellectual property rights are divided into two main areas. One of them is the copyright. Under the copyright law, original works are given copyright protection in order to prevent theft and unauthorized use. Copyright examples include creative works with a tangible form, such as art, science, art, music, and literary works. Copyright works to control the ownership, use, and distribution of creative and expressive works. In this economic story about the copyright, people think that most creators make their creative works so that they can get paid. When the copyright enables creators to get paid, more creators make more works. So this is a short introduction about the topic. Our resource person speakers will discuss about this and solve your queries. I wish you all the best. Listen well, ask your doubts, enhance your knowledge. With these words, I congratulate the Research Advisory Committee and the Department of Commerce, headed by Professor Bhavna Rajput, for organizing such a wonderful webinar. Jai Hind. Thank you.
Thank you, ma'am, for your kind words. Now, I request everyone to kindly switch on your camera for taking the screenshots. Thank you, everyone. Now you can switch off your camera. Now, I take the opportunity to introduce the moderator of the panel discussion, Dr. Shikha Gupta, resource person of SCB, NCDEX, NCFE, CDSL, and PFRDA. And she is also authorized to conduct investor awareness programs across India. She is best known for her freelance services. She has majored in various degrees, including UGC NET qualified, MBA, MCOM from Delhi University, PhD in microfinance from one of the leading institution, Motilal Nehru National Institute of Technology, and NISM Security Market Certificate holder with 95 percentile. Ma'am has a rich experience of 14 years in the education sector. She has imparted financial literacy to more than 10,000 students and faculty across India. She is currently working as an associate professor at Lingia's Lalita Devi Institute of Management and Sciences and holds various positions like career counselor, training and placement coordinator, NAC core team member. She has organized various programs like national, international conferences, corporate interactions, guest lectures, industrial visits, FDPs, job fairs, etc. She is enlisted as an editor in various research journals and has published more than 30 papers and patents in leading journals. Now, I request you, ma'am, to kindly initiate the panel discussion. Over to you, ma'am.
Thank you, Vanshika. I hope I'm audible to every one of you.
Yes, ma'am, you are audible.
So, very warm Good afternoon to everyone. Thank you so much, the principal ma'am, Mamta ma'am, Bhavna ma'am, Ajay sir, and Shalendra sir for being a part of this panel discussion. Along with us, I would be like to thanks to all the participants in the today webinar. So before we start with the intellectual property right, we have this a panel discussion, but before we will be starting with the negative aspects about the, where we stand when I talk about the intellectual property right. So you would be surprised and would feel pride that Ministry of Commerce and Industry, as per the latest updates, has been announced the first time in 2000, in the 2022 January to March, the period of this quarter. It's in the first time in 11 years that we have been extended the number of domestic patents as compared to the international patents. So this is actually a pride moment that Indians are, been taking a more initiative in, filing the IPRs in the Indian context. And we are also thankful to the, Department of Intellectual Property Rights Office that they are continuously been working towards the creating the awareness through NIPAM, which is a National Intellectual Property Awareness Mission. So I'm very thankful to the authorities of NIPAM who have been working back into, increasing the awareness among the youngsters. When I talk about the youngsters, the all of us who are the, the young researchers, the students who are continuously been working on the new innovative ideas. So when I talk about it is only the value my proposition that we are calling it as an intellectual property. No, it is not only the novel new thing that we are calling it as a IPR, right? What we would be calling it only intellectual when it is inventive as well as useful for the industry. So if you have a three combination, which is a new novel, it is an inventive and it is a industrial usefulness, then we'll call it as a intellectual property, and that we need to get patent or we need to create a property or a rights over it. So when I talk about this, these are the three basic parameters we need to keep in mind when we are talking about intellectual property. Just like we have a normal properties like assets in our home, like our car, the home, the house, same here, that are the tangible as the properties. And when I talk about the creation of our mind, which is novel, inventive as well as industry useful, that would be counted as our intangible property. These intangible intellectual properties need to be protected, and for that we have a rights. As all the introductory remarks which I have been just gone through, every one of us has been rightly understand that the property is a kind of intellectual and intangible property that we need to save it from misuse, and that value need to be updated. It could be the product, it could be the process. And when I talk about the various combination of intellectual property, so there are majorly 5 to 6 components of intellectual property. One is the patent, which all are aware, which would be, certainly for a certain time period you would be given the right to protect your any patent. Then we have a design as well. So any kind of design that would be in the form of some say aesthetic properties or some newest innovation in the designing of say chair or car look, that would be counted as a design. Or if you talk about your Apple laptop, a aesthetic design, or a, the Air MacBook, these are all the designs that all carry the intellectual property rights. Again, there would be copyrights, that would be the content we are being protecting from any misuse. We have a trademarks, like we have a right signature in Just Do It, we have a Pepsi logo. So all these logos will be fall McDonald M, they are all fall in the category of trademarks. Along with that, there are certain, the geographical indications tags, like we if I talk about oranges from Nagpur or Mysore silk saris, or if I talk about Madhubani paintings, these are all geographical indication. Similar way, we have a semiconductor integrated surface design as well. So these are all the various, the types of intellectual properties on which you can take the rights if it is innovative. Innovative in the sense the new inventive and industrial usefulness. So these are the basic, the intellectual property rights that one should go ahead. And in the entire conversation, which is going to be start with the Ajay sir and followed by Shalinda sir, we will discuss deeply about all these aspects. We also discuss in the session about the job opportunities. So if I talk about job opportunities, the job seekers could be in the government jobs, that would be of examiners, or apart from that, there would be agents who would be acting as a facilitator, litigations, and all these kinds of, the job seekers or the jobs are into the market. So it doesn't mean that only if you are a finance background or a science background or a legal background, whatever background you belongs to, there would be a lot of ample opportunities to become a part of the intellectual property rights. So there is a opportunity to grow, not even to invent something, but to help the others to into facilitating the process as well. So that would be the added benefit. And if I talk about why we are going with the intellectual property rights, it is basically to competitive edge that we are getting to getting our patents, our innovative ideas as the legally loop and branding value that I'm getting. Apart from that, once I have been created a intellectual property right, I can license it, I can sell it out, so I can earn the revenue as well. So these are the major benefits why I would be looking towards to go for intellectual property rights. Why this session is important for all of you? As I said, all of you are the young generation who are having a young mindset, and you keep up with the lot of new knowledges, lot of new ideas that can put into this intellectual property rights. So you all can work on it. Like I had been work one of my patent recently on the stock market, as my area is stock market. So I have been recently got one of my patent done in the I have not done the patent, but I have been, published one of the patent in the patent rule 2003, and that would relate to the theme of machine learning based approach to study the parameters of stock trading. So it could be any process also that you would be working on it. So with these words, I would like to hand over the session to our speaker, Ajay sir. Thank you so much for giving me this opportunity to speak.
Thank you, ma'am, for joining us and imparting knowledge. Now, taking the discussion further ago, I would like to introduce our first panelist, Mr. Ajay Singh Rajawat, who is a project director, Shastra Rashtriya Raksha University, Ministry of Home Affairs, Government of India. He has worked with Innovation Cell along with All India Council for Technical Education for promoting innovation and startup ecosystem in India, primary responsibilities and managing entire IT systems and cloud for MIC. He is also a member of Smart India Hackathon Committee, Asian Indian Hackathon, India Portugal Innovation Initiatives, India Luxembourg Innovation Initiatives, UNESCO Initiatives. Successfully delivered 25 startups in the Indian innovation ecosystem, 10 more in pipeline, along with 32 patents filed so far, along with young innovators. He has taken part in programs of Ministry of Education as a contributor in entire IT operations for the programs like Kalam program for IP literacy and awareness, school innovation ambassador programs, international hackathon model that enabled Ministry of Education Innovation Cell to work continuously during pandemic. Now, I would like to invite sir to proceed with the discussion. Over to you, sir.
Thank you, Snehal. Though I think ma'am have covered most of the important topics. Uh, when I got an invitation to speak on this topic, though I've been speaking on this IP thing from last 3 or 4 years, and as ma'am rightly said, like it's just 7 or 8 years, the boom of IP is going like nothing, and sky is the limit for the innovators. What they are doing right now, whether from tech domain or non-tech domain, the IP segment is getting stronger, and that too when a recent Controller General for Patents he took charge, so the scenario is little different. So considering all these points, I'm going to mention 2 3 bulleted points to know like what we are doing and are we doing it right or not. As ma'am said, and we all know that importance of IP is still unknown. If I'll say, अगर सरल भाषा में बोलूं तो in our country still the innovator who is innovating on a grassroots level and developing something unique, novel, don't know the value of the IP. So certainly there is a point that IP knowledge and the IP education is required. Why I'm telling you is an example. When previously, when my previous organization, when I was there was one program launched called Kapila, Kalam Program for IP Literacy and Awareness. In that program, there was a provision of for all the higher educational institution, like if you're filing some patents and some copyrights, you can submit those entries on the portal of the Kapila, and your like the amount that you have spent will be 50% reimbursed. That was the point of inducting that particular policy. That time I realized like we are in a race. We know like the name itself defines that patents and IP is something that is novel. But in this race, people are just filing, and filing. Nobody is taking things very seriously for the grants. So, in my opinion, if I say the IP, I never considered IP as just a small piece of paper so that you can put it in your resume. Certainly, I have seen some cases where a potential IP filed by the father is generating millions today. So this is how the knowledge and the education of the IP uh, can be accumulated in the current ecosystem, so that innovators and other people can easily understand that. Coming to the main point of the session, like this is the potential of an IP. If you are having your IP, I'll not say like an IP. If you have something novel that you have filed as an intellectual property legally, and after 2 years, 3 years, 4 years, if somehow like if another pandemic comes in and you have already developed something that can cure these basic like fever and all. I'm just giving an example of a medicine that was patented by these companies who have formed the vaccines for the COVID. See what kind of revenue these guys have generated. Even though after surrendering the IP, the way the revenue they generated, and from their revenue, their countries got benefited. Our country also got a global recognition. Like this is how we have generated something novel that saved many lives. So this is the importance of IP. If you will go to the technical terms, if you'll go get a deep dive into things like these are types of IP, these are the segments of the IP, these are the, just forget that. Just try to understand IP in a simple language. Whatever novel you're thinking right now, while during this session, while working in the laboratory, while traveling in a metro, if you see if you can invent something novel that is solving a problem, can become a potential IP. And when you go through this index mechanism of the IP, like isko file karna hai and we have to do a copyright, otherwise our rankings will not be good. That will be a separate channel. Many institutions are following that. But why I mentioned this particular reason is that we as a nation have to work together on the potential IP creation, not just IP creation. You know, we are too much in population. If one person start filing the patent, then we can file many and many. Like there will be a no end of filing the patents. But when it comes to the potential IP, the quality of the intellectual property, the quality of the novelty innovations we are coming up with, then the beauty of the IP will come up. And considering like last point that ma'am has mentioned that the numbers have drastically they have changed, right? Like till the time like previously when I was in college, I was not even aware about IP, and my HODs and my professors were saying like just focus on your studies. Now this is an era of innovation. This is the time where we can create a potential novel innovation repository from which we can expect the quality IP, patents, copyrights, GIs can be taken out. And when we are going to do this, I'm just giving you an example here. Like here, this is where I'm right now working. Like it's my next assignment is it's Sastra. Scientific and Security Technical Research Association. You know, India has found very less patents in the field of security, national security. And when I took a charge here, I saw that there are so many novel innovations that are coming out of this particular national security and defense, but it's not getting filed. It's not getting recognized. The reason is when the invention was at initial stage, when it was in college, faculties and other people just file it and get rid of it. No one took that particular thing seriously, that this can become a novel solution. It can become a potential IP that can generate some revenue for the person and for the country also. $5 trillion economy, without IP it is impossible. That is what my take it in this particular context of IP. When I did my PG in IP, I learned how USPTO is performing, how UPTO is performing, and how Indian Patent Office is performing. We are still pretty much inclined towards the filing. And to get that target of the $5 trillion economy, we have to just shift the track to start thinking something novel, come up with a potential IP, and get it commercialized. These are the points are not being discussed so far. But being in a era of 5G, like you guys are in right now in college life, you might you're the most tech savvy generation. Like we are the 90s kids, but you are living in the era of the 5G. So whatever you are thinking, whatever you are coming up as a novel idea in your mind, make sure you document it, you file it, and work on it to make it a potential IP so that you can commercialize. So with this, like in my last concluding statement, the session that is right now going on, we need to organize these particular sessions on a larger scale so that we can educate people. Then only we can expect the IP filings can be done. The quality IP filings can be done in future. If we are not educating people on IP, and if we are on a race, like if you will file 100 patents, you will get this much ranking. No, things will never change. Things will remain like as it is. Still, when you see IITs and NITs, they are not in the race of getting rankings. That is the reason the quality of the potential IP are coming in very good. And apart from like other institutions, it's not coming really well. So this is a practical case study. Like when I talk about like Delhi University people I'm not right now interacting with, I just did one practical also. Like I think from my side, what I believe is to find a potential co-founder for a startup and for an innovation idea, DU is the only place where you can get it. And I recommended to many tech innovators also. Okay, Baba, if you want a co-founder, if you want to actually run your business, if you want to come up with a novel solution, get in some insights of a DU student. So I think like I'm really happy like the DU, that too Department of Commerce, is taking up particular cognizance of the importance of the IP. I like to thank Principal Ma'am of Aditya Mahavidyalaya for pushing students to learn IP apart from the accounts, finance, and economics. And thank you all for giving me a chance to interact with that. Love to interact with you guys in future whenever it is required, in terms of IP, in terms of innovation, in terms of collaboration of coming up with some novel solution. I'm there for you guys. Thank you and have a great day. Bye.
Thank you, sir, for sharing your experiences and knowledge with us. Students are now requested to post their queries in the chat box. There's a question from Kashish. She asked, how can we fight the theft of intellectual property rights?
If I say like your question is coming in a way like how you can protect. So right now, till now, the policies are on ground, but still the theft is the only thing that you can deal legally, that in court. So this is the only way that you can fight legally. For that, you need to have a IP attorney with you, and you can file a case, or whether it's overseas or here in India, you can simply go through a legalized way. For that particular thing, you're having a USPTO portal and like Indian Patent Office portal, and the patent agent requirement, a patent attorney thing is required. With that only you can consider this as a simple case that you're fighting in a court.
Next question is from Tanu. She asks, what are the bases of intellectual property enforcement?
When we like, what your question is coming is from the informant side, and I'm actually a kind of a you. I'm not say the specialist. Usually worked only on the filing and the novelty part, so I'll not be able to answer this question in the right direction. Did you go?
Okay, sir. Yeah, Lakshmi wants to ask, what are the impacts if there will be no intellectual property rights?
See, then there will be a ultimate chaos between the startup founders and the inventors. Like I invented this, and you invented this. This is how this is different. So somehow, to remove the chaos and to give the proper credibility to the original inventor, IP is required. So, in order to maintain the decorum of this industry of the innovation, IP is required. And number three, when it comes to the valuation of a particular invention or a product, IP is required. So, if these things are IP is not there, there will be total chaos on all three segments. You can understand, like, when you invented something, someone else is developing the same thing. You can take an example of a famous brand in the past, if you guys are aware about it. There was one biscuit called Yummy, Yummy, that from Priya Gold. There was a famous case study there, like they were using the same uh, recipe of Priya Gold and the another brand in the market, and somehow that tasty biscuit was removed from the market thanks to IP. And I think it answers your question.
Next question is from Ashmita. She asks, what is the duration of the copyright protection?
Right now, till the time the patent, as per the IP office, like there are different duration, but the standard duration can be taken as a 10 years, 10 years or 20 years. But if in case any infringement comes in between, you cannot say that it is going to be a last longer with you. No, copyright thing, if you have copyrighted here in India, then you have to go for the US part, then you go for the Europe part, then certainly you have to protect it on all angles. Then you can say, you can't simply rely on things that you filed a copyright and it's okay. No, there are international boundaries and you have to reach there to ensure that no one else can going to get your particular copyright at their hand. So standard duration is 20 years, but to make sure like it's going to be 20 years, you have to file it on overseas method also.
Khushi wants to know, how can we manage the important date related to intellectual property rights of a company?
Can you repeat the question, please?
How can we manage the important dates related to intellectual property rights of a company?
Dates you are referring to
Dates.
dates.
I'm sorry. Important data.
Important data. So
Yes.
for this particular thing, there is an IMT standardization tools available. So you cannot say this much of confidential information is stored in the IMT standardized tools, so that we can ensure the secrecy and the confidentiality of the document. For example, like if you are filing some patent and you are having entire data on your email got hacked. So this is a standard practice. In India, it's not so common, but overseas the practices are really common.
Sneha wants to know, what is the infringement of copyright?
What is the
Infringement of copyright.
infringement of copyright? Suppose you are using else logo, for example, if you are using a with a little bit of modification, but that particular streamline, color, tone, and everything they have copyrighted, and if you're using it in your particular brand, this is called copyright infringement. So you have to make sure, like, not just only the figure, the color, tone, theming, and all these things are also under the lines of the copyrights. So if you are misusing someone else's property, that is copyright. It's called copyright infringement. Yes, Nehal, next please. Snehal, are you there? Hello?
Sir, I think there must be a technical glitch. There is a question from Anuradha Shukla, and she wants to ask which is the best college for IP and how to get the admission into that. I mean, they are not understanding the question. IP is not, we are talking about the IP college. Here we are talking about the IP rights.
See, this IP, if you're asking for the what is best college for intellectual property, it is not a subject that you can do a master's on. But yes, I did my IP from IGNU. That is to a PGD IPR. So there is no limits because till the time IP knowledge is concerned, you have to gain it at your own, not from the books.
Okay, sir, there is a question from Mr. R. Kumar, and sir wants to ask if I want to file a design patent, how much duration will it be needed to publish and further for getting the grant also?
See, for the grant, there is no time limits for that. Like how the more and accurate information you are providing, and it totally depends on uh, the way that you are going to file the patent, the agency and the patent agent who is actually working on that particular direction. What kind of RA is involved in these particular process? That only so for that particular grant, I think, and not for only for the design, for the patent and for the copyright, time is an issue. And in India especially, like right now the things are getting aligned. Previously it was horrible, so it's going to take a year or more, depending on like how you are providing information to the authorities. And specifically for the designs, the more clear, more explanatory these things of your diagrams and designs are, I think it is that is also directly proportional to the grant time. Yes, Bhavna ma'am. Can you move to the next, please? Yeah, also I would like to have all these questions in a on email also, so that I can give a detailed write up on all these questions, because I think people have. Yeah, any more question, Bhavnaji?
Sure, sir. I'll request, thank you so much, sir, for taking the questions of the participants. Now I'll request Dr. Shikha Gupta to initiate the session and to take the session further.
Thank you, Ajay sir, for such a detailed discussion. And I believe that some of the points which have been asked during the question answer round are very, useful and important for everyone to get updates on. So I'll take this session further with some of the basic theoretical things which we're discussing. So if I talk about, we all of you are the students, right? Make maximum are the students and the faculty members and the resource scholars. So if I talk about the recent the identifier that of the intellectual property rights. So if I talk about generally, that is just take an example of Apple laptop. All of us, I think majorly most of us are being very used to using laptop. So if I talk about the Apple trademark, right? The half of the apple is there as their logo. That would be fall under this category of intellectual property right. What would be the further parameters? As I said initially in the introductory remark about the design. So if I talk about Air Mac, the thinnest, the that would be gadget in your hand. So
Hello.
that would be again, ma'am, am I audible?
Hello.
Yes, ma'am.
Yeah. So if I talk about the design of the Apple laptop, again, that would be a part of intellectual property. Furthermore, if I talk about their processing, the technology that they are using in providing the interface with the laptop, that technology again can be a part of intellectual property. So if I talk about their design, their internal, the circuit, the semiconductor which we call, is a part of intellectual property. So within a same device, I mean the one product, you can have the multiple things could be patented. So here the patent would be available for the laptop of Apple for the design. For the copyright would be available for, say, suppose the content that would be manual available with the Apple laptop. There you can get a copyright as well. The trademark is again the intellect under the intellectual property right. So can you see it doesn't mean that within a one product there would be possibility that you can have the intellectual property related to patent, design, copyright, as well as trademark, and along with that semiconductor design as well. So possible? Yes. And as many of you been asking this related to some queries, infringement and other things, and why we should go for intellectual property rights and all. So I believe there are the research scholars and the students. And how many of you been complain your faculty members that my this or that friend has been copied my entire assignment? I have not given, but still I don't know how they have been copied. My is the original one, and she has been or he has been copied from me. It happens with all of us. Same with the resource scholar. It has been always been given the advice from the mentors to all the research scholars that they have to maintain the secrecy of the topic title, the content, unless and until it get published or you get the degree awarded. What is all this? It is the easiest and simplest way that make you to understand about the intellectual property rights. So if I talk about this, it become a chaos. Na? Everybody is saying, no, my is the original one, you are copying, or you been into, in the a group of people and you said some idea and you just said and somebody been started working on it, then what you say, अच्छा मैंने तो ये बात कही थी but इसने तो ये कर लिया, ये तो मेरा idea था, but have you been implemented it? No, you have not. So same with the intellectual property rights. When we talk about, it's not all about the innovative ideas, but to converting your innovative ideas into commercially into the legal loops, that is important. So that's why we say always it is not only the innovation idea, we have to work on its innovativeness. Is it inventive or not? If it is not inventive, ऐसा नहीं कि मैंने दो products को मिलाया mix करके एक नया C product बना दिया, right? Is it a innovation? No, it is not an innovation. It is not an inventive, right? So mixing of two things and creating a third thing is not the inventiveness, right? So we have to look for not only the new, नया तो है वो दो चीजों को मिला के कुछ नया बना दिया आपने, but does it fall in the category of inventiveness? No, it is not. So we have to look. Then again we have to look the usefulness. आपने इंटेलेक्चुअल प्रॉपर्टी राइट्स के लिए क्लेम किया, आपने किसी आइडिया को क्लेम कर रहे हो, लाइक इट शुड बी कन्वर्टेड इनटू आईपीआर. सो व्हाई इट शुड बी कन्वर्टेड? Does it have any value for the society? Like sir said, Ajay sir, that it should be a problem solving to the society. To somewhere, does it making any benefit to the authority, to the society, to the nation, to the global level authorities? Yes. If it is, yes, it could be fall under the category of IPR, and we should go first. In such cases, the intellectual property right should be continued. So in that case, we would be saying. And if I talk about the minimum time period, so if I talk about the minimum time period for taking the IPR could be 1 year. And if I'm saying about the maximum time, it could be till the life of a person who would be having, say, copyright in case. So till that author is continuing, he can follow this copyright, or it may be vary from various, the patents to copyrights to trademark a different time zone. And from country to country also it varies. The rules and regulations vary for every country, for every different kinds of properties, right? So that we need to take care. And when I talk about this geographical one, we have a traditional knowledge digital library, which is TKDL, Traditional Knowledge Digital Library. library. What is this library is all about? Like we have a lot of knowledge, as I said, ki Madhubani painting, Himachal shawl, chicken of Lucknow, then Mysore silk sari. These are all the traditional thing, isn't it? ये एक particular geographical location से relate करते हैं, and these are our customs and traditional things that we are following and we are updating it. So अगर इससे related कोई चीज हो रही है, like traditional knowledge और digital library हमारा एक है. This traditional knowledge digital library is we keep on updated with such kind of traditional knowledge. So if it would be falling under this category, which is already been into our traditional knowledge and digital library, then such resources or such the ideas will not fall under the category of IPR. तो आप उसके लिए आप intellectual property rights file नहीं कर सकते, right? जैसे चिकनकारी का कुर्ता जो हम सब आजकल बहुत ही कॉमनली फीमेल्स वेरी करते हैं ऑफ लखनऊ, हिमाचल का शॉल है, मधुबनी का पेंटिंग्स है, ये सब क्या है, नागपुर के ऑरेंजेस हैं, ये सब क्या है, ये ट्रेडिशनल उस पर्टिकुलर एरिया को बिलोंग करते हैं. ट्रेडिशनल नॉलेज जैसे कि हम कहें अदरक टर्मरिक का यूज, दीज आर द ट्रेडिशनल नॉलेज डिजिटल लाइब्रेरी में ये हमारे पास ऑलरेडी एग्जिस्ट करते हैं. सो वी कैन लाइक फोल्क डांस है और नीम का यूज है, ये सब क्या है, ट्रेडिशनल नॉलेज है, राइट? तो ये सब हमारे ट्रेडिशनल नॉलेज डिजिटल लाइब्रेरी में है. अलॉन्ग विद दैट देयर आर अदर सोर्सेज फ्रॉम व्हिच यू वुड लुक बिफोर यू फाइल द आईपीआर. तो आईपीआर फाइल करने से पहले आप जितने भी हमारे सोर्सेज हैं, एक हमारा जैसे आप गूगल सर्च करते हैं, सेम वे वी हैव अ गूगल पेटेंट एज वेल. तो हमारे पास जैसे गूगल स्कॉलर्स है रिसर्च जर्नल्स को फाइंड आउट करने के लिए, सर्च करने के लिए, सेम वी हैव अ गूगल पेटेंट एज वेल. सो वट एवर विल बी द पेटेंट्स ऑलरेडी पब्लिश्ड, द डिटेल्स यू कैन गेट ओवर देयर. देन यू हैव अ वर्ल्ड आईपी ऑफिस इज देयर. गूगल पेटेंट्स है आपके पास, इंडिया का इंटेलेक्चुअल प्रॉपर्टी राइट्स पब्लिकेशन ऑफिस है. सो दीज आर द वेरी कॉमन वेबसाइट एंड देयर आर अ लॉट मोर through which you can first need to check whether your idea is innovative or not. Maybe you are feeling it's innovative for you, but maybe somewhere in the the location in the India or maybe abroad or globally, wherever you are filing it, right, it may already been existing and been copyrighted by someone or been patented by someone. That design has been already been into the intellectual property rights. So we have to look, right, where we are filing. That location also matter. Maybe if I am filing the IPR in India, so if somebody from it having a the restriction to be protected in the geographical location of India only, but the moment it would be extended to the say another country, can they use this particular method or the process or technology? Yes, they can, because they would not fall under the IPR. Why? Because it would be only within the country I have been taken the IPR. So there I have to look forward for which location, for which territory I am looking forward to this IPR. So I believe like all these things, if we take care, definitely that would help us to before we are filing the IPR, I would be at a better position. Somebody has asked from where you will get this IPR knowledge. As sir said, the IGNU we have a course. The same we have the lot of the institutes who are providing the short-term training courses, knowledge courses. So where you can get the knowledge and you can generally, if I talk about the scientist, the such kind of category people, technology person, IT person, they are into the examiner. Like we are going to have our next speaker, Shailendra sir, who is the examiner at patent office. So he would be giving you a much more detailed, enlightening the session about the intellectual property rights. I hope all these points have been make it clear to all of you, like how we could move ahead with the intellectual property rights. Ma'am, shall I invite the next sir? Shalin sir, has he joined with us?
Yes, ma'am. And thank you so much. Yes. Okay, thank you so much. Snehal, please introduce sir.
Yes, ma'am. Now let's welcome our next panelist, Mr. Shailendra Singh, who is an examiner of patents and design, International Search Authority, International Preliminary Examination Authority. He is a gazetted officer, Patent Office, Minister of Commerce and Industry, New Delhi. He has been working in the Patent Office since 2016. He is a part of the National Intellectual Property Awareness Mission (NIPAM) under the Ministry of Commerce and Industry. He is a part of the Kalam program for intellectual property literary and awareness campaign Kapila under the Ministry of Education. He has delivered lectures in more than 70 seminars and national conferences in different universities and institutes all across the country. Now, I request you, sir, to kindly proceed with the panel discussion. Over to you, sir.
Thank you. Am I audible to everyone?
Yes, sir, you are audible.
Okay, thank you. First of all, very good afternoon to everyone, and thank you for giving me this opportunity to become a part of this webinar. First of all, I was hearing earlier with the other panelists, Shikha Gupta ma'am and other Ajay sir. So it was very nice that they have given a very good information to all the participants of this webinar. Now, first we need to understand that why this IPR is so much important and why it is coming into the picture nowadays. One thing we need to understand the economic structure of any country. Now, if you see the economic structure of this country, India, now it's changing its structure from a socialist country to a capitalistic type of country, where more and more people are going to have their own businesses or companies or something like that. So if you are going to have your own businesses, your companies, your startups, so you need to have understanding about this IPR, because you need to have the understanding that it's your creativity and how you can protect your creativity, how you can have the monopoly over your products, your design, your patents, your copyrighted things, so everything related to your work. So if you see any other country, any other capitalistic country like China or maybe US, UK, like these countries, you will find out that number of patents filed or copyright filed or these other IPRs filed by them are very much large. If you compare some of the statistics, I just like to share with you all that if you see that number of patents filed by the US in average number of patents filed by US in a year is around 6.5 lakhs, and in China it's around 15 lakh. So, and if you compare it with India, it's around hardly 50 to 60,000, and that too is usually not much participation from the national from the ordinary application. It is usually the international application or maybe any other company which is working internationally. So there is a very less participation of the academics or maybe the institutes in India. The filing is very much low as compared to any other country like US, China, UK, or maybe others. So it is very much important that we need to understand the importance of these IPR in the present scenario. If you see right now that any student who is studying in any college or institute, what is their basic motive these days? What they want to start their own businesses. They want to start their own startups. And after a few years of working in any good institute, what they do, they just want to bring any new idea and they want to start their business. But at the end of the day, what happened, they will not get the actual income what they should have got from their creativity or their work. The reason is that because they are not protecting their ideas, their means their technology or maybe their product. If you see that if you bring any product into the market without the design registration or maybe patent registration, what will happen that other companies like any multinational company, what they will do, they will copy your products. They will see that this is the thing which is liked by the people, and they will definitely bring the product at a lower cost or maybe a better advertising. So you will not be able to sell your products and get the maximum benefit out of your creativity. So it is very much important to understand that how you can protect your IPRs. So first thing is that uh, uh, other IPRs, I think you must have heard with other panelists. I would like to just bring to you all with a particular one type of IPR, that is patents, because this is one of the topic which is most unclear with the people, and people don't understand how to file the patent, what is the what are the different forms in the patents, how they can what is actually innovation, how we can relate these things. So that I am going to touch in this particular webinar. So can I share my presentation?
So you can share your presentation.
Okay. Is it visible now? Uh,
Yes, sir.
okay, thank you. So now it's in the full screen. Is it visible?
Yes, sir.
Okay, thank you. So you can see there's multiple type of intellectual property that we have in our system, like patents, design, trademark, geographical indication, copyrights, and semiconductor integrated circuit layout design. So these are the different categories. Now I was listening to the ma'am earlier, Shika Gupta ma'am, and she rightly said that first you need to understand one thing, that any product can have multiple IPs, like this particular laptop. Now how the Apple company has protected its product. Now this laptop, if you see, now in this particular laptop, each and everything in this laptop is protected under the IP. Now if you see, the design of this laptop is protected under the designs registration. Now the technology that is used in the laptops making and all the things is registered under the patents. The design of that logo is registered under the trademark. Now the programming that is used in the laptop and the other softwares and everything are protected under the copyrights. And if you see, the electronic things that are available in this laptop are registered under the SICL design. So if you see that each and every part of this laptop is protected and nobody can even touch a single thing in this particular laptop. So this is how any company controls the product, how they can have the monopoly of their technology, product, and their creativity. Now, first thing is that who are going, what is the importance and significance of these IPR registration? It will protect the thing, it will exclude others, and it will help you to utilize and commercialize and earn. Now if you see that who are the actual people who are going to invest in this IPR, now it's very common thing that businessmen, definitely, if you are going to start any business, it is going to benefit you all in the commercialization, creating a brand value and earn more. But how it can benefit a common person, now like a professor or maybe a student or maybe a research person, for them how it can be beneficial. So if you see that any person, like if someone is a professor and if they are working on any technology and if they file the multiple patents and research papers and all these, what they are going to do, they, it become a thing of pride for them, and it is also a beneficial in their academics upgradation. If you see any important positions which are held by the people in the institute, like in any university's dean and university's registrar or vice chancellor, you will see their profile, you will find out there are multiple patents, copyrights, and other things, other IPRs which are under their heads. So it's a very important thing for a person, because it will increase your value, it will add the value to your the personality. So today, just I'm going to touch on this particular topic, that is patents, because other topics are very easy to understand, and I think the other panelists have already stated a lot of information, and it is very easy to understand. But this patent is little bit different from others. Now, if you see what is basically a patent, first thing is that patent is a state or a sovereign right. What does it mean? It means that if you are filing a patent in India, it will only be protected in India. You cannot file you cannot say that if I filed the patent in US and now if I say that I can have, I want the protection in India. You cannot have the protection in India until and unless you file a patent in India also. So if you think that how the companies do their work, what they do, they first identify the market, that where they are going to sell the product or where they want to protect their technology. So they first recognize those countries and file the patent in all the different countries where they have the protection. So I have seen so many people filing the patent in US or Australia or maybe Germany. I don't understand the benefit of it. Maybe their reasons may be different, that they want the patent in a very less time, and other countries are providing that it in a lesser time. But if you are going to utilize the product in India or maybe your technology in India, you need to understand that you have to file a patent in India. Until and unless if you file the thing in India, you are not going to protect it here. So one thing is that you need to have the understanding of this thing, that it's a sovereign or state right. Second thing is that it is protected for a period of 20 years. Means if you are filing anything today, it will be protected for the upcoming next 20 years. After 20 years, what will happen, your thing will come into the public domain, and anybody whoever wants to use it, they can use it without taking permission from them. Now if you see the examples of the previous scientists like Ly Edison, phonograph, Graham Bell's telephone, Wright brothers aeroplane, like these, there are multiple examples. And if you see, what people think about the patent is that they think it's a very complex thing, it's something very extraordinary, and for a common person it's not being it's not a thing that we can do. No, it's a very simple if you need to understand the concept of innovation. Now if you see that, you will find out that all the basic innovate all the researchers and everything has already been done by most of the previous scientists, and there is a very less scope to create any new uh, technology. You just need to understand that how you can add on in the previous technology. Now if you see the Graham Bell telephone, now in the telephone you see the what type of telephone it was developed by the Graham Bell or invented by the Graham Bell. It was very different from the today's world. You see the changes that has taken place in the telephone industry. Now earlier it was a wired phone. After that wired phone, we came across with the cordless phones. After that we came across with the mobile phones. Mobile phones also, the technology changed from keypad phones to the QWERTY pad code. After the pad phones, after that we have the touch phones. In the touch phones also the technology has changed. Now these days from single SIM to dual SIM. Now these days we have in the Apple eSIM technology, where you need not to put any SIM in the phone. So these are the upgradation in the known technology in the prior arts. So this is the actually what is the meaning of this, that is innovation. Means how you are going to add some new technology to the known product, which is very new and which solves one of the problem of the society. Maybe in a maybe it will reduce some of the time in some work, or maybe in any other way it is adding some benefits to the society. So if you are solving any of the prior arts problem, if you are solving the problem of the prior art, means any other old technology, and giving solution to that, it is basically an innovation. Now if you see these examples like this hat, now it's a very simple example of how you can develop a product which can solve the problem of the society. Now this cap, what it is doing, it is protecting a child face from getting wet, and it's a very simple and nice nice product. And this way you can understand that you can create very simple products which are useful to the society and which will help the people in a very different. Now just to give you an idea, that each and every company, before filing for before introducing the product into the market, what they do, they first file for a patent. Now if you see, Apple filed for a patent, Toyota filed for a patent, even the government has to file for a patent. It's not like that the DRDO is a government institute, or means BEL is a government institute, or maybe a BHEL is a government institute, or any other company is a government company, then they don't have to file for a patent. No, even each and every institute, if whether it's a government, it's a private or any institute, if they want to have the monopoly over the product, they have to file for a patent. Now the patent application filing. Now the application filing, it's a very important thing for anyone who wants to file for a patent by themselves. And if you also are going to take the help of any attorney or advocate or anyone or any agent, then also it is very much important for you to understand the different forms and to have the understanding of the process, what is going on behind the system. Means what are the different forms. If someone is saying that these forms are required, this much money is required, these forms cost this much, you should have these information so that people should not take the advantage of this. Now there are multiple form, around 30 forms in the patent system, and you need not to have the understanding of all these 30 forms. Just need to have the understanding of these 5 forms, and after that you can file and get the patents. Now the form one. Form one is basically a form in which you need to give the details of the application. Means you need to give the information regarding the means the name of the inventors, the applicant's name, the uh, institute's name, or whatever basic details are required, that you need to give in the form one. Now form two is basically a form in which you have to give the description of the invention. Means you have to describe the things in this particular form. Means you need to give the information in these subheadings. There are multiple ways of giving the information, but this is one of the best way to give the details, because you need to disclose your information in such a way that the people who are going to analyze the thing, your information, who are going to read your information, should understand the thing in a better way. So it is the duty of the person who is filing the application to disclose the information in a proper way. So you need to give the title, background of the invention. Background of the invention means you should give the information that from where you have came to this particular invention. Means you should disclose about the prior arts, like these are the prior art which are already into the picture, and these are the problems which are there in the prior art, and I have given the solution through these ways. So this directly gives the direction to the person who is reading your information, that this is particularly, actually this is the invention which you are submitting. If you are not giving the information about the background, it becomes very difficult for a person that why you are giving this, why the product is why this technology is being developed by this person, or maybe a product is developed by this person. And maybe this also gives the this also gives this type of uh, thought in the person, that this person is actually doesn't know anything about the prior arts. They just developed something and they just filed it. They did not did they have not done any background research on this particular product or technology. So this background of the invention is very much important. And after that, particular of the drawings and other descriptions, these things you need to submit. Now, form 2, there are two ways of filing the form 2. One is the provisional and second one is the complete. Now, provisional filing is basically done when you are working on any application, and after that, and you want that you still need some time, but it is not yet completed. So what you can do, you can file the provisional application, and what happens in the provisional application, you can submit the things incomplete, but the government gives you one complete year to submit the complete specification. So if you have submitted anything today, then after the completion of 1 year, means before that time, you have to submit the complete specifications to the this patent office. So there are two ways of filing this form 2. So this way also you can protect your technology or maybe your work, because sometimes what we think that we should keep we will submit the things after the completion, after the complete information is available to me, and after that I will submit the things after completing everything. But what happened with that, in between the time you might have taken the help of third person or maybe the fourth person. So you have taken the multiple persons help, and what they do, they copy your things and they will file before your filing. So through this provisional application filing, this form 2 provisional specifications, you can submit your thing and you can promote your technology and things. After that comes the form 3. Form 3 is basically a form in which you need to submit the foreign filing details. Means if you have filed any application in India and now you want to file any application in any other country, means like in US, UK, China, then what you have to do, you have to disclose this information through this form 3, that I have also submit the application in these countries, US, UK, China, Japan, XYZ, any other country. Wherever you are filing, you just need to give the information through this form 3. Now after 1, 2, 3, this there is a form 5, declaration as to inventorship. Now this form is basically submitted just to give the information that who are the actual inventors in the particular application. Now what happened if someone has submitted the provisional specification, the form 2, and now they have taken the one complete year to complete the invention. Now in that 1 year time, let us assume that someone has taken the help of earlier only two people were the inventor, but because they will not be able to get the actual result, so what they did, they took the help of two other peoples. And now why these two other peoples are going to help them, they say that you need to make as the inventor in your application. So after the completion of your invention, who are the actual number of inventors in the application? Four. So you need to disclose this information through form 5 that you have to submit after the complete specification, that these are the actual inventors after the completion of the invention. So these are the four forms that you have to submit. Now after submitting these four forms, what happened that your application get published. Now this is the one of the myth in the minds of the people, that publication is a very important thing in the patent application. No, it's nothing like that. It's something like that you have some given some article and you have paid some fees to the newspaper agency, and they have published your news or your article in the newspaper. So it is just similar to that. No one has scrutinized your thing, no one has analyzed anything. Publication is done without any scrutiny. So if you think that if some your application is published and you are going to get the patent, it is nothing like that. You will have to wait till your application is got examined and it is granted. Publication is just the starting phase of the process. So if someone says that my 10 patents are published, so it doesn't make any sense, because uh, I can submit 100 papers and all of them gets published in the gadget, and nobody is going to look after that whether they have I have filed the new things or whether the things are actually a invention or not. Nobody is looking after it. Nobody has read it. The things are being read after you have filed the request for examination, and that happens after the publication. So publication is important, but it's not like that publication is related to the patent grant. No, nothing like that. Publication is done to each and every application. So if you are going your application get published, just wait for some more time and wait till your application get grant. Because actually after examination, people means we analyze and we read your application. Till publication, nobody has seen anything. So after 1, 2, 3, 5, and last form that someone has to submit is form 18. This form is the request for examination that is required to be submitted to the office. So after submitting all these forms, your application will go for the examination process, and it will be processed for the grant or refusal. Now, the fees for the patent application is this. For a natural person, startup, or education institute, the fees is 1600 for the form 1 and 4000 for the form 18. Who is the natural person? Natural person means any individual. It can be one person, two person. It can be a group of 5 people, 10 people. It can be anything. So natural person, startup means you should have to provide us the information from the Ministry of MSME, or uh, that you are a startup, and you have to provide the certificate. Or a small entity also, you have to provide the certificate that you are a small entity. And for a educational institute like Aditi Mahavidyalaya wants to submit any application now, you also need to submit the application with the certificate that you are a educational institute, maybe a UGC certificate or maybe a AICT certificate, whichever application you are having, you need to submit that. So this is the fees for them. For any other who doesn't belong to this category, the fees is this 8,000 plus 20,000. Now there are two ways of filing the application. One is the hard copy filing and another is the online filing. For the hard copy, you need to submit the application at the different patent offices, whichever is closer to your geographical location. You can submit the application there. There are four offices like Chennai, Mumbai, Kolkata, and New Delhi. So if you are in New Delhi, you can submit all the application directly to the office in the hard copy form. For the e-filing, you can do it from anywhere. Just you need to go to this particular website and this type of page will open. You just need to fill, basically you just need to sign up and they put all the basic details and all the forms you will see, and you can submit the things. Now expedited examination. Now earlier what has happened that people have a thought that it's taking a lot of time for the patent to be granted, and people think that we have already filed a patent 2 years back and we are not getting any reply. So because of the pendency or maybe other issues, sometimes it takes a lot of time, maybe 2 years, 3 years. But at least you have to wait for 1.5 to 2 years for any normal process, because this much time is required in any country. If you see, all this much time is required for, at least you have to wait for 2 to 3 years. But if you want to get the things in the very less time, so there is a process that is expedited examination. For the expedited examination, there is a particular criteria that who are the people who can get the benefit of this expedited examination. So for the startup, small entity, any applicant is a female, or if you are a government organization, and the fifth one is the, if you are a ISA, IPA, and PCT, that I'll explain. So if you come under this category, you can go for this expedited examination. Now in the expedited examination, one of the benefit is that you may get the patent maybe less than in a year, maybe, or at max in a year. So you can get the patent. So that is the best process if someone wants to speed up everything and get the priority over other applications. Now the patent application processing, whatever I have explained in the previous slides, comes under the ordinary way of filing. Form 1, 2, 3, 5, 18, all comes under this ordinary way of filing. Now the second process is the convention. In the convention application, what happened that if you have submitted any application in any other country prior to filing in India, means you have filed the application in US and now you want to file the application in India. Now that application is treated as a convention application. Now for that, there is one condition that you need to submit the application in India within a period of 12 months. Means if you have submitted the application in US today, you have to file the application in India in 12 months of time periods within that time. So that other things and everything is almost similar to the ordinary application. Now what is PCT? PCT is basically a patent corporation treaty, which is a treaty under the WIPO, that is World Intellectual Property organization. It is a treaty between around 155 countries, and out of those countries, some of the countries are international search authorities. Around 20 countries are international search authorities. Now what are these international search authorities? These are the authorities which give some particular report on the application which are filed under this category, that is PCT. Now, why this PCT has came into the picture, or what is the benefit of filing the application through the PCT? Because we are already having the convention or ordinary route. Why this particular route? Basically, if anybody wants to understand about the patent application, means whether the things are novel or inventive or industrially applicable, want to understand about the things before filing in any other country, what they can do, they can go for this particular process through PCT mode. Now, in the earlier process, you have gone through this particular way. Now, if you have filed the application in 5 countries, now after 5 countries filing, submitting all the fees in all the countries, what will happen at the end of the day? Let us assume that 4 countries rejected your application. They say that it is already available and you will not get the patent. Now, why this has happened? Because you don't know whether the information that you have given is a novel thing or not. You don't have any information and you are not an expert about the search and all these things. So what you can do, you can go through this particular process, that is PCT. Now, in the PCT process, you need to choose any ISA. Means you, if you are an Indian, you can choose any other country as a ISA also. You can choose US, UK, any what who are the ISA, which countries are ISA. You can choose any other countries also. But if you are choosing India as a ISA, because India is also ISA International Search Authority, you get the benefit of this expedited examination. This point, India as a ISA in IPA in PCT. So you become eligible for the expedited examination. So if anyone who is a male candidate, or if you are a company which doesn't come under the startup or small entity, what you can do, you can go for the PCT process, and you can through PCT process and choosing India as a ISA, you become eligible for the expedited examination. So in the ISA, what will happen? We receive your application. We will give you some information regarding the novelty, inventive step, and industrial applicability, and this information will help you out in the filing in the different countries in a way that you right now you will have the actual thing that if ISA, International Search Authority, says that your application is okay and everything is okay, now the chances of getting the patent become very high. Now there are some applications which are not which you on which you may not get the patent, that is atomic energy related, and that is defense related. So if your application is related to these two categories, what we will do, we will first send your application to the concerned department, and after that, after getting the approval from those departments, you may get the patent for them. Else, you, if they don't allow, if they say that these are related to these category, then you will not get the patent under this particular category. Now the examination process in the patent application, we do the examination, that is formal check, technical check. After the formal tech check and everything, we send you the FER, that is first examination report. Now in the first examination report consists of all the information about the novelty, inventive step, and the industrial applicability, all the information and all the objections we will send to you. Now you need to reply on this thing within a period of 6 months. So after that, after getting the reply from you, we will recheck your application and do all the checks and everything. If everything is okay, we will grant you the patent. If everything is still, if there are some pending issues are there, then we will go for the hearing. We will ask you for a technical hearing, and in the hearing it will be a discussion with the person, maybe an applicant or an inventor, whoever it is. So after the hearing, if everything is okay, then you will be granted a patent, else it will be refused. Now if you see the examination process, this examination process has happened after the publication. So till publication, no one has looked after your application. So don't give importance to the publication of the patent. Patent publication is just the starting phase of the process. So this is the basic timeline for the thing. Now for the provisional to the complete, that I have already told you, it's 12 months. Request for examination is 48 months of timeline. So these are the timeline for the patent application. This was all about the patent and patent application filing. Now, if anybody has any question regarding these things, or if you want to understand anything more about the things, then you can let me know.
Yes, sir. There is a question from Anuradha Shukla. She asked, which is the best website to apply for patent? Because many people make fake website and also they can copy our ideas.
Best website to apply for a patent, what does it mean actually? First of all, you need to understand that the only way of filing the patent is through the government website, that is ipindia.gov.in. And if you are taking the help of any attorney or maybe an agent, then it's up to you. If your person is known to you, you can choose anyone. We cannot suggest anyone that he is a good or she is a good. Uh, eh, all are same. So you can take the help of any agent, but filing through any website, I don't understand this thing. Because you cannot apply for a patent. You can file a patent, and that is only through the IP India website. So it cannot be fake in this thing.
There is a question from Vanshika. She wants to know if there is any exceptions to copyright.
In which sense she is asking exceptions? In which sense in the copyrights? Basically, copyright is basically given to the particular set of things. That is, it may be a literary work, it may be a singing, it may be a dancing, artistic forms, it may be a painting. So, like these type of category of work, we give the copyright and all. In the copyright, one need to understand one thing, that for the copyright you need not to file for anything. Means if you are not filing anything, it and if you have published the thing on internet, it means it comes into the copyright protection. You need not to get the certificate from the government that it is a copyright protected thing. If you are publishing anything on internet, it directly comes into the copyright protection. The only thing is that if you are filing the copyright in the system, means in the government, what will happen, you will get some authorized paper that this particular work is a copyrighted work. So it's not necessary that you need to file the thing to the government for the copyright claim. The If someone files someone on the that YouTube or maybe any other website. So what happens that YouTube also is a way they are publishing all these art forms or all these songs or maybe other things. So from that also you can have the protection. If somebody is copying your thing, you can go to the court and file the case against them for this thing if they are copying. And even the companies also, these YouTube or maybe Facebook or Instagram or any other website, they also, what they do, they also provide the protection for the copyright. They directly stops the if somebody copies your thing and publish it, they will directly remove the work if it is copied by anybody.
Vanya wants to know if our personal information is safe while registering a copyright.
Yes, yes, no, personal information in what sense you are asking? Because if you are giving this information, means you need not to give any other thing. You are just giving the your name and basic address and basic details. Nothing else is required. So I don't think there is any issue regarding the personal information.
Isha wants to know can transfer of copyright is possible?
Yes, yes, it can, if it's possible. It's up to the proprietors that if I have no objection, anybody can use my thing. If it is up to me, if let us assume that I have developed this technology, this phone. Now, if anybody is copying it and I don't have any issue, then they can use it and they can utilize this information without taking my permission also. But if I have an issue, then I can do the legal activities against them. And I can also transfer. Basically, use this IPR protection is basically is helpful in this particular way. Also, we usually transfer this information to the companies or whoever is interested in this thing. Now, let us assume that you are a lyrics writer or someone like that, or maybe a uh, book writer. So what will happen if you are like you have seen the Chetan Bhagat. Now Chetan Bhagat has written multiple books. Now what he has done, he has given the rights to the producer and director to make the movie over the books. So that is also transfer of rights only, of the copyrighted work, or maybe any other work also you can transfer these rights.
Mansi wants to know the difference between intellectual property and copyright.
uh, Intellectual property is the overall like you can say that intellectual property is just a word, and these are the subheading in the intellectual property. Means intellectual property, we call it as the property which is developed from our brain, means our intellect. So anything whichever is developed from our brain, our intellect, is still intellectual property. Copyright is one of the part of that intellectual property. Patents, trademarks, the other things. What are these? These are just a part of intellectual properties.
It looks like we have covered quite many queries. Thank you, sir, for answering them well. Thank you for enhancing your guidance. Now I request everyone to please switch on your camera for taking the screenshot. Thank you, everyone. Now you can switch off your camera. Now, I request Ms. Vanshika Goel, Student Coordinator of Research Advisory Committee, to express formal vote of thanks.
Thank you, Snehal. It's my privilege that I have been asked to propose formal vote of thanks in front of you all. On behalf of Commerce Department and Research Advisory Committee of the college, I, Vanshika Goyal, President of Kaizen, the Commerce Association, would like to express my deep sense of gratitude to Dr. Shikha Gupta, resource person from CDSL, Mr. Ajay Singh Rajawat, Project Director, Sashatra Rashtra Raksha University, Ministry of Home Affairs, and Mr. Shailendra Singh, Examiner of Patents and Designs, NIPAM Officer, Ministry of Commerce and Industry. I really thank you all for giving us your valuable time and enlightening us with your guidance. I would like to thank our principal, Professor Mamta Sharma, for her support. I would also like to thank our TIC and convener, Professor Bhavna Rajput, for her minute-to-minute guidance and support. Last but not the least, I thank Snehal Jain, President of Research Advisory Committee, for coordinating this session, Vanya and Anushka for technical assistance, Khushi Bajaj, Associate Vice President of Kaizen for YouTube streaming, Mansi and Tanishka for beautifully coordinating with and making sure in the completion of the event much successful. Thank you all. Now,
Thank you, Vanshika. Now, I request everyone to kindly stand up in the honor of the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Attendance cum feedback link has been shared in the chat box. E-certificate of participation will be given to only those who fill the feedback form. I repeat myself, attendance cum feedback link has been shared in the chat box. E-certificate of participation will be given to only those who fill the feedback form.